Happy Friday Night Live, law nerds. We have a lot to talk about tonight. From Tom Girardi being rendered ineligible to practice law from the State Bar of California, because, they finally did something. Too little, too late, perhaps. We're going to talk about it. There are a lot of updates in the Tati Westbrook case that we've covered over the last 2 weeks. And we didn't have a lot of time to answer questions, and I've had some more time to collect my thoughts. So we are going to talk about those two cases and have a lot of time for questions because we've been needing it, and it's Friday Night Live, so it's just time for a chat. And of course, court of public opinion right here at the end. Cannot wait to get into it because, y'all, there's a lot to get into. So let's just get it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Before we get into anything, though, I need to know what you're drinking this evening. We've got watermelon booch, watermelon vodka, and I'm going through the votes because y'all voted in the text crew about what colors we're going to tonight. Look at this. Y'all have smashed this. So I'm looking through to see what's winning. We've got a lot of votes for purple, a lot of votes for blue. I'm still not done scrolling. Like, there's more. Y'all have sent thousands of votes to the text crew this evening. So I think we're purple and blue tonight because I've gotten green just got axed. There's no green. It got axed out of here. Yeet. Sorry, green. Yote. But yeah, purple and blue totally won. So we're going to change the lights. If you're not part of the text crew, textemily.com from your mobile device. It's working again. There was a minute there. Something on the back end wasn't coded right. Probably because I do a lot of that myself, and sometimes I just mess things up. It's just, we're professionals here, people. Professionals. I think something was not coded right in the forwarding of it, so it should be working now. If you go to Text Emily from your mobile device, it'll just pull it right up. So let's change these lights to purple and blue. I love seeing what everybody is drinking. Sorry, guys. Sorry, green doesn't go here. Green doesn't go here today. Maybe we can do green on Wednesday. You know what? We'll do green on Tuesday for coffee and cursey words in celebration of St. Patrick's Day. And then people are going to be like, no, we also need to do orange for, we'll do green we'll do green. We'll do green on Tuesday for coffee and cursey words. So let's get some of these lights purple, some of these lights blue. I don't see very much purple. We need to change it up a little bit here. You can be purple. You can be purple. I feel like that's equal representation of purple and blue. Yep. Pretty happy with that. All right. We've got purple. We've got blue. We've got it. Well, no, I feel like we need a little on the bookshelf. Also, it's going to absolutely change the way my camera is perceiving light at the moment. So that's always helpful. All right, good. Purple, blue. Hopefully I still look like I'm in color balance, but whatever. It's Friday. We're here. We're here to talk. We're here to have fun. My 8-year-old Owen has been really wanting to catch you live. So here we all are. He said to tell you he is drinking apple juice. Owen, hello. I sometimes say the cursey words. Those words are words you earn when you turn 18. So just be like, oop, Emily's putting a quarter in the curse jar, because sometimes that happens. But hello, it's so good to see you live, Owen. I hope you're having fun. My kids are at swimming this evening, and then tomorrow we are picking up new four-legged friends, and I will share that tomorrow on Instagram. So and I'll let you know on the Twitters, of course, but we're getting new four-legged friends. So it's good to see everybody. All right, we did that. I don't want to miss things. I'm trying. I caught a live. Yay! Feeding my 6-month-old while he naps on me, and my 3-year-old wrecks the house drinking iced coffee from Australia. Amelia, I've been there. One of the most stressful things for being a mom of 2, hello, True Sleuth, for me was when My youngest was still nursing, and you're like pinned down under baby. This child, by the way, when people are like, oh, sometimes when they're little, it's hard to tell their personality. This child, my little one, G, he would nurse forever. And this kid will still enjoy like a 2-hour dinner. Like, he is a grazer. He will just hang out and eat forever. And so when it was just me at home and he was nursing, it was not always easy to just carry him around as my 4-year-old was running amok everywhere. T, who's now 13, who all of you guys, we're just going to take a little Law Nerd Love moment. I shared a short that my kiddo made on my community tab, and I'm definitely not here on the YouTubes to be like, shout out to my kid. But he came in last night during my live and asked a question, and then I posted something on the community tab, and a lot of you went and checked out his short, and he was just blown away this morning when he got up about the views on it, and he was just so happy. So the text crew, anyone can be in the North America right now can be in the text crew. I'm sorry. North America right now can be in the text crew. There's a VIP text crew for our highest level members, which is a separate part of the text crew. And if you become a member at that level, you get the instructions on how to do that. But for the for everyone, you can get in on the notifications. I respond to them when I can, and do text back and see things that you guys text me. In the VIP crew, it's a lot faster turnaround than in the regular text crew. And I see everything the VIPs send on the list. I don't see everything everybody else sees. I do my best. So any kind of phone, just need to be in North America. Adam McIntyre, good to see you. Don't spill the beans. Adam has seen pictures of the four-legged friends we're picking up, but I haven't shared with the Law Nerds yet. They get to see tomorrow. Good to see you. So yes, having one kid nursing and one kid like running amok in your house is actually terrifying. It's just, you have no control. It's like, okay, we're going to just let go. We have to just trust that everything's going to work out. But now, anyway, 13-year-old, I shared in the community tab the short that he had made. When I say he made, he drew the art that's in there. He edited it. He filmed it. He set up the tripod. All I did was say, hey, you have to do hashtag shorts with an S that's capitalized to get it onto the shorts shelf. And he was just blown away by the support of all of you. So thank you. Thank you so much for being so kind. I very, very much appreciate it. And thank you guys. Thank you. You don't get community tabs on your device. Okay, I'll link it in the description here too. But what I appreciate about my kid, and the only reason I would ever like share stuff he did on the channel, is because he does it on his own. And maybe Tech, I don't know how to do that. Not getting community tabs on the device. Tech might have thoughts on it in the chat. But when I ask him what he loves most about making YouTube videos, it really is the making of the videos that he loves the most. He loves creating them, editing them, and he puts them out and is just like, I love everything, including putting it out there. I mean, he's got videos that have like 2 views. So he is really focused on the process and the joy of creating. And that's something that I want him to continue to find joy in, because as creators, it can be very hard to, it can be very hard if you get caught up on the result, because we as creators aren't in charge in any way of the result. Like, we can't at all control how it gets picked up, how it's perceived, if people, like it, if they don't, if they watch, if they don't, if YouTube notifies people, if YouTube unsubscribes people, which a lot of you have been telling me lately has been happening. We don't have control of the results. We only have control of our own actions, our own creation, the way we engage with our community, and the way we make our videos. That's all we have control over. So having him enjoy the process, that's the part he can control, not the outcome. And that's something that I've always really tried to stress with my kids, is when we get very outcome determinant, it is very easy to get stressed, anxious, caught up, depressed, all the things. And I had been outcome dependent most of my life. If any of you have seen my TED Talk, I was very, very outcome dependent. It doesn't matter how much effort I put in. It doesn't matter how much I enjoyed a thing. It mattered on what the outcome was. I don't know if that's because it's just part of me, if that's because I'm ADHD, if that's because I love external validation, if that's because I was an athlete and sometimes like, oh, good game, we didn't get it this time. It's like, no, fuck that. We were awesome and we lost, and that sucks. So I don't know where I ingrained that mindset from that became so outcome determinant. But going into criminal law and doing as many trials as I've done, and I've done a lot. I was thinking about that today when I was looking at these Tati Westbrook documents. I'm like, God, I've done a lot of trials and I've had shit go off the rails, and nothing has gone off the rails quite like this. And we're not even at the trial part yet. But once you get into trial, being outcome determinant, I find for me could lead me to being a very bad lawyer, because the outcome's not my responsibility. As a criminal prosecutor, my responsibility was to do justice, to make sure that a trial was fair, to make sure that I picked a jury that could be impartial, not just to my victims and witnesses, but also that I thought would be impartial to the defendant, because the defendant has constitutional rights too. Making sure that I presented the evidence ethically, clearly, in a way that a jury could understand, that I made victims and witnesses feel respected and heard, that I presented the best case I could present. And if I did that and the jury came back not guilty, then that was the right result, even when it's frustrating. So not being super outcome determinant became really important to me as a district attorney. But then I shifted my determination to validation within the office, the types of cases I was getting. Like I kept shifting to these different measures of external validation. And I'm so glad that I started to grow on YouTube after I had done the work to not be so outcome determinant, to shift into me. And be like, look, if I'm happy with what I'm putting out and I'm happy with the interactions I'm having and I'm happy with the community that I'm creating, then, you know, mileage may vary on the things we do on the YouTube. I'm excited about the sub numbers. I mean, you guys, we're at 90.7 today. And this, based on back end numbers, might flip over while we're live. I mean, if you haven't subscribed, go ahead. And that's a good metric. But getting to talk to all of you is the fun part for me. Yes, numbers are fun. Yes, it can be exciting, but it's not my validation. Getting the DMs from you guys, and I've gotten so many this week, especially in the conversations around David Dobrik and consent and those cases. So many messages from you saying, I needed to hear that. I needed that validate. I needed to hear somebody else say that my experience wasn't wrong, that my response to things wasn't wrong. And we're going to keep talking about those things on this channel. We're not done with this conversation by any means. Some days are lighter than others. Today is going to be a lighter day. But that is really where I gauge how we're going, by how we're going for the community and how we're building together to make sure that we're having conversations that are meaningful and sometimes just fucking fun and shady. Like sometimes we're going to have fun. Sometimes we're going to be shady. It's fine. It's for fun. But sometimes we're also going to have conversations around really hard concepts where the law and how we feel in our guts with the morality of things don't always unite. And I love those conversations with you. And I love that you're here for it, because I've seen a few things, but very, very, very few on the Dobrik case. And mostly it's people who just don't love my conversation about what the law is and what it isn't. And in that case, people saying, but if this person did this, and I'm like, right, actions after don't change what happened in this moment. And it's talking about those snapshots in time that can be hard. And if we do talk about the Chauvin trial going forward, it's going to be discussed from really my experience as a criminal prosecutor. So I don't know how I got onto that wild galloping Like we ride into a tangent, like we rode into a fucking tangent. We just tangent. We galloped into tangent, talking about my kid. Tangent. Two Golden's Pawners. I saw a question here that I wanted to answer, and this can be a huge problem, Stephanie. So can a jury reach out to a lawyer if they have questions about the trial? Now, if it was the jury that was on the trial, they can reach out to the court. But we've seen cases where jurors have reached out to lawyers saying, hey, weird stuff happened in the jury room. And then there are investigations in juror misconduct and things like that. So tread with caution. Jurors really only get to know what they know from the trial. But if jurors have questions, reaching out to the court is always the first place to reach out if they have something that they need to kind of talk about. So that. I've been wondering how difficult jury selection will be in the Chauvin case, the Floyd case right now. I saw they were in the process. They are in process. I have not gone into a lot of the coverage for cases like that, and I'm sure this is the case there. In cases like that, there will be questionnaires and there will be lots of vetting. How much have you seen about this case on social? Do you already have preconceived notions? A lot of people already probably have preconceived notions. And so to take a step back from that and say, can you listen to the facts and what the law is, might be hard for a lot of people because we have such visceral reactions to not just the Floyd case, but what happened after it this summer, the way the officers acted. Some people are like, I don't care. I cannot listen to this. And I do not like what that officer did. Because remember, the officer, Chauvin, is the one on trial. He's the one who has the constitutional rights for the trial. So it will be, when we talk about it, it will be when I'm more caught up because I'm not going to get into stuff that I don't know about. But with jury selection on a media case, on a case that's been broadly out in the public, there will be questionnaires before they even get into jury selection. And then from the questionnaires, there will be questions from the lawyers, questions from the judge. Being on a trial like that can be very stressful. And you also don't want people who are like, I'm going to be on this jury. I'm going to write me a book. It's going to be amazing. Chef's kiss. So you want jurors who understand what this is and understand that they're there to do justice. And that can be a hard thing to find in a media case. Absolutely, for sure. So yeah, that's what that is. I saw a few other questions come in about other cases I'm covering. I've put out a poll to the members at the level who help put that in, and then a poll will go out to all members over the weekend to see what we're kind of getting into next, because there's been a lot going on in the two cases we're going to talk about today. So in the cases we're going to talk about today are updates on Girardi and kind of my thoughts in a like, not a step back, but a little bit more about what I'm thinking about what's going on in the Tati case and that. So we're not there yet. This is what I wanted to bring up. The only real evidence. No, circumstantial evidence is real evidence too. Circumstantial evidence is evidence too. Oh, but this is an evidence class. Evidence is so much. Evidence is so much. So I agree with you. I think that in some cases in the media, people refer to trials by the more high profile name. I call it the Chauvin trial because Chauvin, I'm going to pronounce it wrong, is the one on trial. But yes, I think it helps. The victim is not the one on trial here. And there was actually a settlement with Floyd's family today from the city. So yes, I tend to go by defendant name, but it is something that's common. I mean, even when Scott Peterson was on trial, a lot of people called it the Lacey Peterson trial. For me, I try to stick with the defendant's name because the defendant is the one on trial, not the victim. So in this case, though, because George Floyd is the one who murals were made of and the one whose name was in the media the most, I think a lot of people don't realize how the languaging around how we talk about things needs to change. So I absolutely try to talk about it by the defendant's name. So All right. What's the biggest screw up you had when working at the DA's office? Don't answer if you're not comfortable sharing. Bart, that's a really tough question. I think one of the things that was most difficult for me, I had a particularly difficult judge, and I don't mind sharing this story, and then we'll get into the two cases. And I didn't have a lot of things go wrong for sure, but all attorneys make missteps, and I definitely had some, and I'm not embarrassed to share that because all attorneys make missteps. And I think normalizing missteps is something that's very helpful because we're not perfect. The thing about being a district attorney is sometimes when you make missteps, people can end up dead. And that's very, very scary. And that's something that's I've seen happen to my colleagues in multiple occasions. So that is challenging, but that's also not the DA's missteps. That can be the court's not redacting something, the court's turning over something that shouldn't have been turned over, and addresses getting out and things like that. So I absolutely am mindful of that. But for me, I'll share that story. And then in the chat, I want you to tell me, and then we'll do the two topics and questions. In the chat, tell me, please, if you want to get into Tati first or if we're getting into Girardi first. So Bart, I had a case that I was getting ready to go to trial on, and I had been in trial like 4 back-to-back over 2.5 months. So it was trial after trial after trial. The judge I was in front of fucking hated me. The feeling was mutual. Occasionally, I still check the obituaries to see if she's still alive because, you know, she's Vader and she's scary and her presence still looms large. But she hated me. She hated me. I will tell those stories another time. She hated me. She made me cry more than once. She called my boss because I would sometimes say "you guys" to the jury. Also, "you guys," very much a California phrase, very much common in the early 2000s. She didn't like that I didn't say "ladies and gentlemen of the jury" all the time, because once we got into knowing each other after weeks, it'd be like, okay, you guys, this is what it is. It made her insane. Did I continue to do it knowing that it made her insane? Maybe sometimes, but also that was my natural vernacular, and that was how I worked with a jury. That's how I talked to a jury. Like the way I talk to you guys, but with less curse words and vernacular, because the judge would get mad. So I had a gang case with it was a carjacking, attempted murder, and there was some other stuff, but the carjacking was like the main thing at gunpoint, and then the attempted murder and stuff. So there was gang evidence, and in California, the gang evidence is like a separate thing. So it's like the crimes are all of this, and then there's this allegation that it was done for the purpose or in furtherance of gang activity, and that the individual was a known gang member, blah, 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 blah. Yada, blah, et cetera. The pretrial hearings became an issue because my gang detective who had worked on this case was in Hawaii as it was getting ready to go to trial. They had a family member pass away. They had a subpoena to be in my court. They left and went to Hawaii. So I was like, okay, Your Honor, the gang detectives in Hawaii, these are the other detectives in the unit that can come in. And the defense attorney's like, I don't have reports from these other detectives. Fair, by the way. Annoying, but fair. I don't have these other detectives. I don't have, don't have reports from them. I don't have any of this. We can't go forward with any of these. So the judge struck the gang allegations, meaning she was like, she yoded it. No gang evidence for you, Emily Baker. I don't want you to talk about gangs. I don't want you to mention gangs. We're not proving gang evidence. You have to go to trial. You do not have extra time. There was also some other evidentiary stuff that went down with this guy being on vacation because the supplemental detective was like, hey, there's this other report. And that was a mess. So I'm not mad at the ruling. I get it. That particular gang unit was kind of disorganized. So gang evidence, no. So as we get into jury selection, they read the jurors a list of all of the witnesses, because if you know all of the witnesses or any of the witnesses. You can't really be a juror if like your neighbor happens to also be a police officer and you didn't realize it, because when they say like, Officer Dan, you're like, who? But when they say their full name, you're like, wait a second, I know someone named this. Could that be my neighbor? Or like the other dad that coaches on the softball team, or like my kid's friend's mother. Like, you never know. But if the jurors know the witnesses, it's a problem. So you read the whole witness list. So we get in a whole veneer, which is like the whole fucking crew of jurors. Get in the whole jurors. They're all in the back of the courtroom. And I keep pointing behind me because when you're sitting there, it's like the judge is there. And then from the prosecutor, if I'm sitting in prosecutor seat, the judge is where y'all are. The jury box is over here. The defense attorney and the defendant over there. And then the veneer is back behind me. So it's a whole courtroom packed full of people before they get up into the little box. And then you call the first group into the box. You ask them questions. It's like one out, one in. Anyway, so she's reading the witness list of the veneer, because you don't even need to get up into the seat if you know if you know some of these detectives. So if you know some of these detectives, your ass doesn't sit down. She's reading out the list and she gets to the last one and says, okay, who's this detective, Miss Baker? And I was like, the detective? It's the detective? And she's like, which detective, Miss Baker? I'm like, the detective? She's like, which detective, Miss Baker? And I'm like, the detective. Miss Baker, which detective? Your Honor, the detective from the gang unit. Miss Baker, you cannot say. She lost her mind. I was like, what did you want me to do? You kept asking me which detective, which. I'm like, the gang detective. She lost her mind. I knew it was coming, but she lost her mind. She kicked out the entire jury, called my boss, yelled at me. She's like, you've wasted all of this juror's time. I'm like, did you want me to call a sidebar? She's like, no, I wanted you to tell me it was the detective. I'm like, I kept telling you it was the detective. I kept saying it was the detective. So it was the gang detective. And she was like, and I'm like, she lost her mind. So that was probably one of those moments in court that I really wish I could have taken back. I should have pushed harder for a sidebar, or should have sat silent until she forced me to a sidebar, or kept saying the detective from such and such police department's special unit. Like, there are other ways I could have handled it, but after a month and a half of back-to-back trials, sometimes your brain doesn't work the way that it works in hindsight at 15 plus years later, right? So that was one of those moments where I was like, ooh, I could have done that better. In hindsight, I could have done that better. So yeah, with her reading off the list, which detective is this? The detective. But which detective is this? The detective. But which detective? The detective. Yep. She wanted clarification, but she didn't want me to say the thing that clarified. Anyway, that was one of the highlights in my court. I mean, the other screw ups was like, me tripping and falling in court and landing on an unhandcuffed defendant who was facing life plus $1 million. Not actually $1 million, but he was facing like multiple life charges on armed robbery. And I completely fell into his lap because I tripped over the cuff in my pants with my high heels. And he was uncuffed getting ready for trial. Same judge. She got really pissed about that too. And I was like, I'm sorry. She haunts my dreams. She was a difficult judge. So I tripped and fell in a defendant's lap, and I was like, this is how I die. He was also very lovely and was very sweet and was like, ma'am, are you okay? Yes, I'm fine. Holy shit. Anyway, nothing I have ever done comes even close to the shit that's gone on with Brown. I just can't. And I've seen you guys say that you want to hear about the Tati case first. So we're going to talk about the Tati case first because why not? So let me pull those up. I've got all my Girardi stuff pulled up. I'm going to pull up. That's not helpful as things go awry. I'm going to pull up some of the documents because I wanted to look at the emails again with Brown. because the emails Brown put in the record, I think, are going to be the thing that bites him in the butt. So let's go ahead and just say it's time to talk a little bit about the Tati Westbrook without a crystal ball defamation case that's not a defamation case. It is just now a pissing match between two lawyers. We are deep into these attorneys. And it's not even like, it's not even conceivable anymore how this is even necessary pre-litigation. Like, we haven't even gotten to jurisdiction yet, for the love. We are still so deep in this case, and there have been so many motions. I have a case brief on it. I have a breakdown from yesterday's video. The things that are happening right now, and I actually said something yesterday I want to correct, but the things that we're in right now are these two motions from Brown. A motion for sanctions against Saltsy. Mom, Saltsy did shit. Make him pay me. And then a motion to qualify counsel. Like, can I still be on this case? And Saltz has responded to both of those motions. Yes, there's an opportunity for Brown to reply, which means if Brown chooses to reply, that'll be due next week. I'm mentally blocked from that possibility. Like, no, nothing else needs to be said. Brown has said in this motion for sanctions the same thing he said over 500 pages of other declarations. And we're not even to jurisdiction yet. We're not even jurisdiction yet. We're not even there yet. Like, she doesn't even go here yet. The case isn't even in Washington yet. And Brown has like wrecked himself with this. My opinion, the judge is going to be livid when she gets to the whole, like, Brown said this, that, and then that's not what it actually said. The judge is not going to have it. But Brown, in his motion for sanctions, no, it was the motion to qualify counsel, includes a whole bunch of emails, including one from Jazzy Jeff. Now, Jazzy Jeff is local counsel in Washington for Tati Westbrook. Remember, you have to have counsel both places. Brown included a veritable fuck ton of emails in a lot of his motions. In the motion to qualify counsel, it's not as many. It was like 6 or 7. But this last email, for me, could have avoided this entire motion to qualify counsel, because Jeff Belanco's email sums up the entire thing. It sums up the entire thing. So let's go ahead and share screen and pull that up. The thing I wanted to correct from yesterday is that I had said nothing else should be due, because I was mentally blocked from the fact that Brown can reply, because in my brain, I don't think he should, but it doesn't mean that he can't, which means the judge will not rule on these until the time has passed for Brown to reply. He is not obligated to reply, but he may file a reply. And if he files a reply, those will be due 7 days apart from each other. And so we'll see those next week and the week after. Let's all just take a minute and hope that maybe we just don't. Maybe we just, like, may reply doesn't mean shall reply. So let's just maybe not with that. Maybe not. All right. So Brown says, thanks, Jeff. Well, let's just go through these emails again, because I think it's helpful. These are the ones with my Katie in them. We're going to go through these again. Chelsea, yeah, I'd be surprised too, but we can all hope. So this is Brown emailing all the attorneys. And look, all the attorneys' emails are public record. I just scroll them up. Don't email the attorneys on this case, like, ever. You'll end up being like Lorianne. It's a joke, partly. Cautionary tale. February 1st, from Brown to Saltz et al. I've looked into the matter of disqualification since you informed me last week that you have no intent to challenge my ability to continue as defendant's counsel based on Lori's statements in her declaration. I believe that under these circumstances, the motion to qualify can be obviated by a stipulation confirming your intent in that regard. I would like to proceed in that manner. I'd like you to agree. I am attaching a draft stipulation for your review. Hey, can you say it's fine? Can you please say it's fine? Say it's fine. I think these are the My Katie ones. Yeah. Well, if they're not, then they're the other ones. I could be wrong, but they might be, if memory serves. But there's been a lot of emails and multiple motions. Hi, Michael. From Jeffrey. I don't believe there's anything to stipulate to in this instance. Even if we did stipulate to such a motion, I don't feel we should be precluded from raising an issue if one, it becomes an issue later on. I have never been asked to stipulate to someone being qualified to represent a party, so I'm not sure why that is necessary in this instance. This is Belanco's very appropriate and kind of a polite way of saying that, hey, this isn't relevant yet. It's not ripe. There's not much we can say. So what do you want us to do? So Belanco says, not much we can do. It's not ripe yet. Brown, let me provide more context for why I think I need to file a motion to qualify or get your stipulation. No, Jeff, you're wrong. Let me tell you why you're wrong. You prepared a declaration for Lori in which she appears to say she believed I was her lawyer. No, she says that. There's no appearance of that. But now that we've gone through Saltz's reply, opposition, to Brown's motion to qualify, you understand why what Lori perceives is so important, because it's that subjective belief. So that is what Brown is saying. Hey, I read in this declaration of Lorianne that she had a subjective belief that I was her attorney, and therefore this could be a problem. You claim she said that to you when you made contact with her around January 12th. You also said in her declaration that she had some interests that conflicted with My Katie's interests. Yes. I agree with you that that might be a typo from my client, but it should have just stayed my client. There's no reason to call KJ Katie in a professional email between lawyers. Just saying. By putting that in her declaration, you were suggesting there is a conflict with me proceeding to represent Katie and WOACB. Again, without is one word, therefore it should be WACB, but okay. I get it. It just bugs. I can't just proceed with the threat hanging over my head that you will move to disqualify me. You clearly indicated on our call that you have no intent to do that until it's relevant. I understand that. If you will commit to that in writing, I do not need to bother the court with a motion to qualify. A motion to qualify that you can't really file because there is no such thing, because a motion to disqualify gets filed when it becomes relevant that somebody needs to be disqualified, but okay. Hi, Michael. I think it's important to distinguish between what Ms. Barnhart states in her declaration and what I have said. I don't think you can attribute statements made in her declaration to me or any of the lawyers for plaintiffs in this case. Right. Because she's someone who provided a declaration. She's not represented by SALT at all. She is someone who provided a declaration, because I imagine that when she went to provide a declaration, here's how that went. Oh, I don't have to imagine. They said it in the motion for sanctions. And they said what they said was, hi, Lori, happy to talk. We don't represent you. You know that we don't represent you. Are you clear that we don't represent you? We can file a declaration saying what you said, but we do not represent you. Yes, we can say that it's not that Lorianne, but we don't represent you because we're not your lawyers. You can consult with another attorney, but we are not that attorney. We cannot tell you what to do. That being said, I don't know what relationship actually existed, if any. So asking me to stipulate to the existence or non-existence of a relationship you may or may not have had with a third party seems to put me in a tough spot. Because it does. I don't know if this is an issue or not. Not ripe yet. And I don't want to waive my right to raise this issue if and when I learn more, which is why I stated that a stipulation from me now may not be worth anything because I would reserve my right to change my mind if and when more information becomes available. Right. When it becomes a problem. Like, it's not a problem till it's a problem. And once it's a problem, it's a big fucking problem. Thanks, Jeff. What I want is simply a stipulation. Reflecting what Michael said on the call, you have no current concerns that would cause you to ask for disqualification. Right, but that could change at any day. I'm not asking for you to waive any argument that might arise based on information you discover in the future, although I can't imagine what that would be. That Lori-Ann's a necessary witness that you'd have to cross-examine, maybe like that. I revised the draft stipulations to clarify. Please let me know. See, what Jeff is saying is that, like, this isn't a problem yet, so I don't need to stipulate to anything because it's not an issue yet. If it becomes an issue, then it becomes an issue when we raise the issue. So this is pointless. And what Brown is saying is, yeah, but I want you to stipulate. And if they did stipulate, imagine what Brown would say then. No, I thought they were stipulating to the whole thing. Like, Hi, Michael. This is not my recollection of what was said during our call. My recollection is that what we represented was that we didn't intend at that time, because it's not relevant yet, to make a motion to the court on that issue. I do have concerns about the issue. We all have concerns about the issue. The scope and parameters of any relationship or lack thereof you may have created with Ms. Barnhart during your communications with her is not something I'm prepared to stipulate to. Nor do I think that a stipulation to not raise the issue now while reserving my right to do so later is of much use. Yeah, literally not worth the paper it's written on, because it means nothing to say, we'll stipulate till tomorrow, and then if something changes, this stipulation is irrelevant, because that's just a waste of paper too. I'm not sure what the motion is that you intend to bring before the court, because there's no such thing as a motion to qualify. Is it your intent to ask the court to make a finding of fact that there was never an attorney-client relationship between you and Ms. Barnhart? If so, I don't believe I have ever seen such a request to a court in this context. Psst. Brown, you can't do that. That motion doesn't exist. It's not a thing. It's a motion to disqualify once it becomes ripe. That's it. That's your only option. A motion to qualify is not a thing. I also don't think that my stipulation would have any bearing on that determination. Buddy, this is irrelevant and you can't make that motion. And we're not going to stipulate. And we don't think it's a problem today. But it could be. Right. And that one email from Jeff, that email is basically expanded into all of Schultz's response to the motion to qualify counsel. Here's my problem. Brown had some kind of a relationship in an attorney sense with Lori-Ann. Do not take that out of context. We are just talking about an attorney-client relationship, or at least a consultation where personal information was disclosed. Then Brown shared all that information with all of everybody, including the court. So if you guys went over and watched Natalie Lawyer Chick, there's a video that I shared last week where she's talking about an attorney that was held in contempt because this attorney was throwing her client under the bus and being like, whatever, he's this, he's that, blah, blah, blah. And she went on a very eloquent rant about this is what you cannot do to your client. It doesn't matter what your client says to you. What you can't do is take it to the court to make your client look bad. You can't do that. You can't do that. It doesn't matter what your client said. Like, if your client threatens to kill you, then you can go to the court in a closed hearing and say, Your Honor, I have a conflict and I need to be off this case. But it is limited. That's not what's happening here. It seems to me that Lori-Ann gave Brown information and confidence that he is now using against her to try to throw out her declaration. And that's like exactly what the fuck you can't do. And that's exactly why these rules exist. You can't go to an attorney in confidence and then have them turn around and use that shit against you, which is why conflict rules exist. You can't have a party to a lawsuit and then also have the attorney that's working on that represent another party that might come in. Lori-Ann can be a witness in this case. Even if the court even if the court dismisses the motion regarding jurisdiction, jurisdiction still has to be proven at trial. It's one of those things that gets hammered into your head as a young trial deputy. Don't forget, you have to prove this shit happened. For criminal law, for me, like, you have to prove this happened in the county of Los Angeles. Do not forget to ask the question, and is that in the county of Los Angeles? Because you have to prove the jurisdiction in every trial. So this could come up if this goes to trial. Do we know if this is going to go to trial? No. So it's not relevant. This could come up if there's a hearing with regard to KJ's declarations somewhere down the line. This could come up if there is a sanctions motion against Brown somewhere down the line. This could come up in a lot of different ways. And it's unknown how that impacts. But what is known is that Brown can't get information from Lori-Ann and turn around and use it against her to try to discredit her, disqualify her. Also, it's not relevant yet because in a motion to dismiss, which is where we're at, all of the evidence goes in favor of the plaintiff. We're not at a hearing yet. We can't impeach witnesses. We can't use their prior statements against them. We can't do any of that until they're called as a witness onto a stand to testify live, in person or by Zoom, and then be cross-examined. And the Washington rules state that if that's the case, the entire law firm's out. All of it, the whole firm, nobody else. You can't do it. Brown has put himself in a pickle. He's trying to undo the pickle, and the pickle's not going to be undone. He's made pickle ice cream out of it. Meaning it's so enmeshed that you can't separate the pickle out from the ice cream. It's a bad analogy. Can the court, Babs, make a finding of fact that there was no attorney-client relationship if the plaintiff is asking for a jury trial? Yes, down the road, that can happen. There are things where the court is the finder of fact, but the court can't hear this yet because a question's not ripe. This is still a hypothetical. So, or the court, this is still a hypothetical. There's no motion to disqualify, and that's the vehicle that the court hears this in. The court's going to look at this and be like, this isn't even a thing. It's stricken. But the court's going to give them time to do all their responses. And the thing is, he filed this motion and is just running up litigation costs, and I don't know the play here. It's so crazy. Thank you. That is a much better analogy. You can't take the egg out of the cake. Yes. I'm glad the analogy makes sense to y'all. It's a fruit salad mixed in a blender at this point. You can't pull the strawberries back out. Everything just ends up tasting like strawberry. And that's part of this. Brown representing all this stuff to the court, filing a sealed declaration regarding Lori-Ann is what you can't do. And it seems that there's an attorney-client relationship there for me. It's a subjective standard, and he's done exactly what you should have done. And just it's a mess. And then the sanctions motion is a mess. And I just worry what the court, I don't worry what the court will do. I don't understand, because this is not like just doing shit crazily is not a strategy. This also puts the attorney on the back foot with the court. The court is going to be defensive after reading all these things. We've got Brown, shortened time abolished, qualified, not a thing. Yeah, Tifa, you're right. And so this is something where the court is now going to be like Brown sus. And that is not, you don't want to be the attorney that the court's keeping the closer eye on. You heard my stories earlier. I've been the attorney that the court's keeping the closer eye on because she fucking hated me. Because I said, you guys, and laughed sometimes. So you don't want to be that lawyer because it can hurt your case and it can hurt your client. Your job as a lawyer is to put your own shit to the side and do the best for your client and not run them out of money, not do things adverse to their interest. And creating an attorney-client relationship with Lori-Ann is adverse to KJ's interest. The best thing for KJ is if Lori-Ann had shut the fuck up, never come forward, and those DMs and texts and information had never come out. The best thing for KJ is if Lori-Ann had never said in a court document, oh, we mass flagged. Oh, we did this. Oh, she asked people to do this. Oh, we emailed. I told her my life story. We did this and this and that. It would have been best for KJ if none of that had ever come out into public record, because not only does it impact potentially her YouTube channel because it speaks of impropriety there, but it could impact what she said in her declarations, because now there's a witness saying the things in her declarations aren't true. And then her declarations are saying, I don't even know her. Who is she anyway? And my declarations are like, bitch, you know me. This is how you know me. You don't want the court already being sus. Remember when the biggest thing in this we talked about was the difference between residence and domicile? Oh, weren't those the days, doll? Weren't those the days? That was 700 years ago when we were all like, residence, domicile. All of this still in jurisdiction. Yes, we are. Yes, we are. And aren't we sad for it? But yes, we are. The other thing I've seen with this, and I've seen it a couple times now, and I'm going to pull that up, is that I talked about it yesterday too. I'm going to talk about it again briefly. There are proposed orders to all of this stuff. When the opposition is filed, I will keep saying reply. Look, sometimes I default to criminal things. When SALT files the opposition, they file proposed orders with all of them. It says proposed. It says what it is. It says their side. It is hereby ordered. These are filed by the parties. Defendant files them too with their motion. They're like, here's my motion. Here's the proposed order. Once these are entered, they're signed and they're entered into the docket. These just being filed is procedural. It doesn't mean anything's been signed. And I've seen that a couple times where people are like, see, the judge ruled on this. I'm like, no, those are proposed orders. They're not lined out. I've seen them on Reddit and stuff like that. These aren't lined out. They're not orders yet. The judge has to sign them and cross out proposed, and then it becomes the order. That's done so that the judge has them ready to go and the judge doesn't have to craft their own order. Sometimes the judges will still craft their own orders. That was part of my job. I used to do that too. So when I was a civil research attorney, but oftentimes it'll be like, oh, this side filed this side filed this side wins. I'm signing their order, lining out proposed, entering it into the record. So with regard to this case, the motion to qualify counsel, I think, will just be thrown out on its ass. I don't think the court's even going to grant or not grant. The court is going to just throw it out and be like, either this isn't ripe, this isn't a thing. I cannot grant any relief to this. Like, there's literally no relief that can be granted from the court. Literally not a fucking thing I can do about this. What do you want me to do about it? Nothing. Strike. But the court's not going to strike it until the time to reply has passed, which means it's a whole clusterfuck waste of money on the motion to qualify. I think that there is a huge issue there. Whether it will come up, we don't know. Could the defense withdraw their motion to dismiss based on jurisdiction? Yes. Could the defense stipulate to jurisdiction at trial so Lori-Ann's not relevant? Yes. There's a lot of things that could happen where this might not matter, but it might. which is why you can't determine it yet, because it might not matter. I've said that enough. With regard to the sanctions, I don't think sanctions are going to be granted. I will be shocked if sanctions are granted. I think fair, turnabout is fair play on this, though, which, Uno reverse. Do I think Saltz will at some point bring a motion with regard to sanctions? Possibly. Do I think Lori-Ann could make a complaint with all of this? Yeah. I mean, he put information under seal that she told him in confidence, believing he was her attorney, and it's adverse to her interest. Yeah, she could bring complaints. So there's a lot that can still happen with regard to these two motions. I'm shocked by them. And Brown indicated he still wants to file a Rule 11 sanctions motion, and the waiting period for that's almost up. So he may still try to file another sanctions motion. And all of us are going to go, oh, don't do that. Don't do that. Don't do that. Don't do that. The time to pull the car over has passed. The time has come to put the rock on the gas pedal and put the car in drive. Yes, we've reached the Thelma and Louise part of this case, and we haven't even started yet. I don't understand this at all. It's wild to me. Query, is it because he knew Lori-Ann and KJ were friends, he wanted to control that? Yeah, very, very possibly. Brown said in a lot of this, like, hey, it doesn't look good. They're trying to do this. So in all those emails, Brown just says, hey, it's best if you guys aren't seen. Can you file a declaration that says this and that versus can you tell me what happened? There's a lot of stuff in this that is sus that I don't like, but I have so many videos at this point, one at least for each filing, that we've been over it. But my thoughts on this really are the motion for sanctions is not going to be granted. The motion to disqualify counsel is going to be thrown out. Then we're going to have to rule on jurisdiction. I still think the jurisdiction could go either way. With the Lori-Ann declaration, it's a much stronger case for sanctions. It looks like, without a crystal ball, has a agent in the state of Washington. So could the court grant jurisdiction? Yes. Could the court grant the motion to dismiss on jurisdiction? Yes. I'm interested to see the court's ruling on this. And I want to see the legal reasoning. When I pulled up the ruling in the Haley Page case, you saw how many pages of legal reasoning was in that. The court spelled out exactly what they did. I hope to see that on this motion to dismiss. And that might be why it's taking so long, because the jurisdiction issue is interesting. There is interesting law there. There is actually like legal meat there where the judge is going to have to look at the case law, look at the facts, and decide. And it can be appealed. So there's a lot that can happen in that jurisdiction motion. I just hope we get there sooner rather than later to see what the legal reasoning is and like talk about the law, and not these two attorneys wanting to get in the octagon with one another and not being able to. So they're just going to use their client's money to do it. And by that, Brown has instigated all of that. Jazzy Jeff sent an email literally saying, A, that motion's not a thing. B, it's not relevant yet. He said it. Can someone take Brown's computer away? I mean, the court could stay them from filing any motions, but she seems disinclined to rein in the attorneys and said in that court call, look, I want the attorneys to act like adults. We are going to move on to the Girardi updates, and then I'm going to take questions. So as I pump through all the stuff that's going on in the Girardi case, if you ask me questions, I may not see them because I'm going to be going through documents. So ask me that at the end. We're going to get into the Girardi case. For those of you that may be new here, do the YouTube things. Go ahead and subscribe, like the video, all the things. Do the YouTube things. If you are not familiar with Tom Girardi is was at this point, was a famous and venerated LA trial attorney. He's known by the plaintiff's bar. He has billions. Yeah. Billions with a B. Billions of recoveries in massive toxic tort cases. That's like when shit's wrong and somebody's injured. Like the Aaron Brockovich case, which he was referenced in. Like the Lion Air case that he's currently being sued over. And this winter, the house of cards that was the Girardi Case law firm fell. And it seems that Tom Girardi has been embezzling money. And I say seems, these are allegations. However, some of them are staggering. It seems that Tom Girardi has been skimming money from clients. People haven't been paid. There have been now over 100 lawsuits against his firm, which is just unheard of. I have multiple videos and podcasts about it going on. We are now in the thick of a forced bankruptcy, which is a unique situation. A forced bankruptcy is when all your creditors get together and go to court and are like, yo, this shit's bad. This person needs to be in bankruptcy. Bring them in. And they force you into bankruptcy. It's just wild. So he's been forced into bankruptcy himself personally and his law firm. Now, remember, he is still divorcing his wife. She's divorcing him. Erika Jayne of Real Housewives. It's expensive to be me. That. Looking this good don't come for free. It's expensive to be me. Yes, her, Erika Jayne, Real Housewife, Beverly Hills. If you want to see me talk about the housewives, by the way, I do that more frequently than you might suspect over on Up and Adam's YouTube channel. And we giggle and talk about housewives. Well, I giggle. Adam doesn't really giggle. He looks at me like, girl, get it together. And I talk about housewives. Either way, if you want to see me talk about housewives over on Up and Adam's channel, we talk about housewives. Erika Jayne, Real Housewife of Beverly Hills, musician things, is married to Tom Girardi. She apparently didn't take Girardi as her last name because in all these court filings, it's got her maiden name on it, which is interesting to me. She's interwoven in this. One, she filed for divorce as the house of cards started to fall, and the divorce is frozen. Not like let it go, but the divorce is paused because of the bankruptcy proceedings. So what's going to happen is with the bankruptcy, they're going to sell everything they can sell, kind of like in, Big Little Lies. They're going to sell all of the shit that can be sold. And then what's left over will get divided up in the bankruptcy court. I suspect that's going to be a big old goose egg, that they are going to sell down everything except living expenses. So thank you guys. I enjoy being on Up and Adam too. So they're going to sell down everything in this bankruptcy. And then what's left will be divided up in the divorce if we get to that point. So the bankruptcy courts have been very busy. There are two bankruptcies, one for Tom Girardi personal, one for Girardi Case. The Girardi Case law firm one, I've broken down a little bit more. And the trustee in that case has started suing other law firms. I imagine at some point they're going to file suit against EJ Creative, Erika Jayne's company. Erika Jayne's company has defaulted in the Illinois case. The Illinois case is the Lion Air disaster case where the court was like, where is the money for the clients? He's not playing at all. I'm referring this to the prosecutors. I need to know what everybody knows. That judge has been very, very active in pushing this case forward. And I think is part of what helped this house of cards fall. Also, because it was not in Los Angeles, I think there was a big benefit for the other law firm involved that hadn't been paid and became concerned that clients hadn't been paid to sue there because Tom Girardi didn't have this grasp on the court. Now, the LA Times came out with the LA Times and I don't always see eye to eye. I don't see eye to eye always on anybody. The LA Times investigative reporters Harriet Ryan and Matt Hamilton did a great job digging through how Tom Girardi seduced the state bar. I have said it on this channel more than once, like, how in the fuck has the state bar not done anything? Because most lawyers, it's like beaten into you. If you set a penny out of line, investigators are going to knock on your door and be like, you're disbarred and you're going to jail. And you're like, it was 15 cents. We can redo the accountings. I'm sure it's just an error. Oh my God, it's fine. And we're talking potentially hundreds of millions of dollars because he had billion-dollar settlements. And now there's over 100 lawsuits when you track it all the way back. So we will talk about the LA Times article in a moment, but I want to show you what the state bar did finally, because I've seen this reported wrong too. And that's okay because not everybody knows. Girardi Thomas Vincent, not eligible to practice. Look at his bar number, y'all. 36603. Like, it's so low because he was admitted to the practice law before most of us were born. It's fair. He's 81. He was admitted to practice bar. What is this? 52, 54 years ago? That's a long career. Most people are retired. So, not eligible to practice law. Look, these phone numbers are out of order. Do not call the Girardi Case firm. It's just full of accountants trying to figure out the books at this point. And this business is part of these lawsuits, this location. But not eligible to practice law in California, ordered inactive. Look, this is the important part. He has not been disbarred. If he was disbarred, this would say disbarred. He has not been disbarred. So under additional information, it will tell you why. He was ordered inactive because of the conservatorship he's been placed under. So this will give you the licensee status definitions. Look, not eligible to practice law. Those listed as not eligible may not practice law in California. There are several reasons that may result in this status, including suspension, involuntary transfer to inactive status, failure to pay mandatory state bar fees. Disbarred lists it as disbarred. Inactive lists it as inactive. Inactive's like, hey, I'm going to Thailand for 3 years. I'm a licensed attorney, but I don't want to pay my bar dues and I don't want to have to take my continuing education. So I'm going to go inactive because I'm not doing shit with that right now. So inactive means it can be chosen or it can be forced. But when it's an involuntary transfer to inactive, it's not eligible. Because when you're inactive, you can come back and be like, hey, I'm back. Can we resume my subscription, please? That's a very crass way to say it, but it is what it is. So he's ordered inactive. He was ordered inactive by the court, rendered not eligible to practice law because he's under a conservatorship. The conservatorship has now submitted documents in court saying that Girardi has Alzheimer's disease and therefore is under a conservatorship. I have all those documents. We will go over them in another day. They are not... unless you want to, do you want to go over them now? Do you want to look at what the doctor said? Should we let me know if you want to hear what the doctor said. How much are state bar dues? Over $500 a year. And then you have to take all the continuing education classes and you have to pay for those too. So he has Alzheimer's disease according to the documents filed in court. So we've got all of the documents. I downloaded those from the court. The physician has, you guys want to see him? Okay. You're all like, I want to see. We're going to go through this and that, and then I'll pull it up. Dr. Nathan Lavid, a Long Beach forensic and clinical psychiatrist, met with Girardi. Psychiatrists are doctors. This is probably the court-appointed psychiatrist. Met with Girardi on February 26th as part of the conservatorship case initiated by his brother. Found major impairment, severely disorganized thinking, delusions. Girardi has dominated civil law in California for decades, winning billions in judgments for plaintiffs in product liability, personal injury, toxic pollution cases, depicted in Aaron Brockovich, married to singer Erika Jayne of Real Housewives. His venerable firm, Girardi Case, collapsed in December. We have multiple things on that here. So dementia impairs his ability to understand the hearing. Let's just pull that document up real quick. Again, this is what the doctor has said. So this is what the doctor has said. It is what it is. We'll see. These documents will show if there's a medical exam or not. Let me just pull them up. Let me find them first because they came in and now I have to find them. I thought I downloaded them, but I don't think I did. We'll do them now. No, there we are. It's a whole process. Look, Pacer is so much easier, y'all. Pacer is so much easier to work with than the LA County Superior Court. I'll tell you what. So that's not it. We're going to pull up a few of these. Hold on. Download. This is what being prepared looks like. Where are my doctor's reports? Doctor's reports. That's not it. That's the case cover sheet. And they all come separately, which is also so annoying. That's the order for hearing. So there's going to be a hearing about this on, let's see the hearing date on here. Oh, this was from the February 1st hearing. That was a different one. That was from the February 1st hearing. All right, one more. Please be our medical records. Yes, thank you. Here we are. Medical records. Yay! All right, let's pull this up. Y'all are like, yeah, let's just do it. I'm like, yeah, let's just do it. Why not? Why not? Why not? Why not? You get to see how the sausage is made in real time, which is always fun to do. You guys I have so many documents in here. It's crazy because this case has so many documents. It makes my head hurt. Thank you. Y'all were just chatting amongst yourselves. You're just chatting amongst yourselves. All right. Civil case cover sheet. Shepard Mullen is the attorney for the temporary conservator. Shepard Mullen's a pretty well-known law firm. For sure. So the doctor, California license, physician, 2 years experience. This is all check marks. Ability to attend court hearing. Because of mental inability, the proposed conservatee is not able to attend the court hearing. Remember, this is going to have been filled out in the Brittany case as well. This in the Brittany case, though, is, I believe, under seal, but it talks about whether they can attend the court hearing for themselves, what have you. In the Brittany case, this is the same thing that was checked. Now, these are the same, not this one, obviously, but these are the same documents that would have been done in the Brittany case. So this is what that looks like when we get into the beginning of a conservatorship. Because of medical inability, the proposed is not able to attend the court hearing for the foreseeable future. Supporting facts: dementia impairs his ability to understand the hearing. Evaluation. So this gets into alertness and attention, information processing, ability to modulate mood and affect, and we'll see what the doctor says. This is literally how this goes in a conservatorship. These are all just check boxes. So alertness and attention, levels of arousal, B, A. This is A, no apparent impairment, B, moderate impairment, C, major impairment, D, so impaired as to be incapable of being assessed, E, I have no opinion. So a lot of these have moderate to major impairment. Orientation to person. Again, we are not doctors. We're just reading what is said without reading into what is said. But a lot of these are B and C, which means moderate to major impairment. And A, like oriented to the person, he knows who he is. Short-term memory, more impaired. Long-term memory, less impaired. Immediate recall, moderately impaired. Understand and communicate. And then these are all signs of impairment. So C is, again, major impairment. B is moderate impairment. So these are all different areas of cognition that are impaired. Ability to modulate mood and affect. The conservatee has a pervasive and persistent reoccurrent emotional state that appears inappropriate to the degree to his or her circumstances, secondary to his dementia. So that is what they are saying, that there is an inability to modulate. And those are all moderately inappropriate. So anger, anxiety, fear, pain, and helplessness. And again, I can understand that. If he has dementia, which is what this doctor is saying, I imagine the sense of helplessness is probably very distressing. And that's a really sad thing. However, it's very sad that in this, I will say, it's sad for what he is going through. However, when we get into that LA Times articles, these lawsuits from clients go back years and years and years. And all of those people, all of those lawsuits are people that trusted this lawyer, to make them whole when they were injured in a plane crash, in an explosion, by a company, by toxicity, by medication. And they've been affected by this greatly. So while I have empathy for somebody struggling with Alzheimer's, it does not erase everything that's been done to these individuals. And so my sadness for this is empathy for a human struggling with mental impairment, if that is the case, which this doctor says that it is in this court document. But it doesn't erase how frustrated I am for every client that's ever trusted him. So, the proposed conservatee's period of impairment from deficits indicated do vary substantially in frequency, severity, and duration. His emotional distress is directly related to his dementia and exacerbated by his confusion. Other information stated below: suffers Alzheimer's disease with late onset. And then the code: ability to consent to medical treatment, lacks the capacity to give informed consent on any form of medical treatment. So this would have been also what was checked for Britney Spears, right? She does not have the ability to give consent on her own medical treatment, which is why her conservator does it. And then proof of service with all the addresses, which again, they seem to have put on all of these, which I'm not going to share. Erika has been served this. So this would have been sent. This was sent to Erika. This was sent to his brother. These look like home addresses. This was sent to his daughter, his son, and another daughter. So, oh, I know where some of those places are. It was like, hey, that one's kind of close to where my parents live. So yeah, but these are home addresses. So I'm not sharing that. And I hope others don't either, because people are going through enough. What they don't need is their home addresses shared. So it's sent to Erika, Jacqueline Lyra, his daughter, Matthew Girardi, his son, and Jennifer Crane, his other daughter. So those are the medical documents that have been submitted by the court. What this doesn't make clear here, I'm just going to pull this up so you can look at it while I'm looking at it, is what testing was done. It does not say. So they met. I saw the conservatee on 2/26/21 based on medical inability. The proposed conservatee is not able to attend, but it doesn't talk about what forms of testing it goes through. This form is not a rating scale. It's intended to assist you in recording your impressions of the proposed conservatee's mental abilities where appropriate. This could have been just a face-to-face meeting with questions and impressions. It does not talk about any medical testing that was done. So let's pull up the LA Times article. No, I'm getting out of order. The other thing that came in with that I think is important, there was an objection to this, and I wanted to pull that up and look at that together. So let me find that real quick. Let me find that real quick. Here it is. Let's save it and go through this because this is interesting. Wait, where did it save? No. Don't do that. I need to be able to pull it up. And we want to be able to pull it up so we can all see it, because this involves the state bar. And let's see what they had to say. Yes, let's. Ugh, of course it closed. See, this is why it takes so long some of these days. We just. That's why we're doing, on this case, I'm going to do another podcast episode, another Emily Show episode that does like from the last point in time to this point in time, because it's so much stuff. But I love that y'all are chatting amongst yourself. Yes, this was a court-mandated doctor because the brother filed for conservatorship. So this would have been the court's appointed doctor who goes through and does these things and does these evaluations. All right, let's pull up this objection. I find it sus as well, and a lot of people have said that, but it also could be, it really could be that this is something he has been struggling with, and he refused to let anybody see what was happening, and that people have been concerned, but out of fear of him and his reputation, that they said nothing. And I took that away from the article in the LA Times, that there's a potential that people were very concerned, and he wouldn't do anything about it because some people can be very obstinate when it comes to their mental health and not wanting to say, oh, I have to step away. So this is verified objection of interested party, State Bar of California, to petition for temporary conservatorship of person and estate. So the State Bar has filed an objection in this case. And I am, where is the rest of it? I am fascinated. And I'm not seeing the rest of the page. Did only the first page save? Okay, hold on. Let me find why and alleges as follows. Well, where is the rest of it? Good Lord. Did it only one page download? Okay. We have to re-download it. See, when I say things like the LA court website is difficult, it's because the LA court website is difficult. The one for the one for Pacer is much better. The federal court's much easier to work with. All right, verified objection. Verified objection of interested party, State Bar of California, to petition for temporary conservatorship of person and estate, declaration of Melanie Lawrence. Sorry. Have you all seen Easy A? Melody Bostic. Anyway, fantastic movie. One of my favorites. Love it the most. It takes up a lot of space rent-free in my head. The State Bar hereby objects to the petition for temporary conservatorship of person and estate and respectfully asks the court to order further inquiry, order a neutral medical examination, and set an evidentiary hearing for the reasons set forth. Temporary conservator's petition was filed under highly unusual circumstances. That's State Bar speak for it's sus. It comes only after proposed conservatee Tom V. Girardi became enmeshed in mounting legal troubles and is facing imminent State Bar discipline. Interesting. Although the petition alleges that Girardi suffers from dementia and is unable to care for himself. By the way, y'all, this was filed legitimately today at 11:47 a.m. Pacific. You're hearing it here first. Although the petition alleges that Girardi suffers from dementia and is unable to care for himself, as recently as November 2020, 2 months before the petition was filed, Girardi was holding himself out as a legal expert and moderated a legal education panel discussion with leading trial attorneys and presented on complex litigation strategy. Damn! The tea is scorching. I'm going to have to do a whole video on this. The State Bar came in with like, no. We're not doing this. These facts, as detailed in the declaration of State Bar Interim Chief Trial Counsel Melanie Lawrence, it's not meant with disrespect to Melanie Lawrence. It's a movie reference. I'm sure Melanie Lawrence is amazing. Filed herewith, belie, God, I love lawyers, allegations that Girardi is now incapable of caring for himself, such that a conservator must be appointed. By the way, the medical was filed, like this was filed today at 11:47 this morning. These medical records were filed yesterday. No, the 10th, 2 days ago. So when I say these things move quickly, these things are moving quickly. All right, Melody, let's get back to what you have to say. Of course, I've messed it up because I went back to look for that date. No. Come back. I'll never let go. All of the movie references tonight. It's just, look, lines for movies take up a lot of space in my head. Song lyrics as well. Oh, and like everything my entire family wants to order at every restaurant we've ever visited, somehow that's mom knowledge that's like required to stay in my brain. But when my kids are like, Mom, what do I like from here? I always know. I always know. I need to stop enabling that. Okay. Filed herewith, belie allegations that Girardi is now incapable of caring for himself, such that a conservator must be appointed. The evidentiary record in this proceeding is sparse. Y'all ain't said shit about shit yet. As the capacity declaration filed in support of the petition is materially incomplete and does not provide the court with the information required to decide the petition. The brother is the one who said, I think there's a problem here. Serious and inequitable consequences will result from granting the petition based on the current record. You can't do this. If the court proceeds to grant the petition, it will impede the ability of the state bar to prosecute Girardi for alleged serious violations of the rules of professional conduct and the State Bar Act, and undermine the state bar's ability to protect the public. Where the fuck have you been, though? But where the fuck have you been, though? And undermine the state bar's ability to protect the public and preserve confidence in the integrity of the legal profession. But where have you been, though? In light of the unusual circumstances of this petition and its potential impact to the state bar's public protection mission, you say that now. The State Bar respectfully requests that the court allow a fuller record to be developed before deciding the petition, order Girardi to be examined by an independent expert, and set an evidentiary hearing. You're involved. The LA Times called you the fuck out. You're involved now? Mm-hmm. I've got questions. The State Bar's interest in protection of the public. Okay, we're going to pause this for a minute. I'm getting red in the face. I can feel it. We're just going to pause. We're going to go to this LA Times article and we're going to pull up exactly how many cases they uncovered, because it was here. We're going to control F it. I'm going to control F myself and find it. Let's go with lawsuit, not lawsuits. Here we go. The warning signs about Tom Girardi flashed after year. Allegations that he skimmed settlement money, inflated costs, abandoned clients, and cheated colleagues. The vaunted? This one's new for me. Can we go back to venerated? The vaunted Los Angeles trial lawyer, a regular, I don't know if we'd say he's a regular, on Beverly Hills housewife and his firm were sued more than 100 times between the 1980s and last year, with at least half of those cases asserting misconduct in his law practice. State Bar. Since the 80s, there have been over 100 lawsuits, half alleging misconduct. 50 fucking misconduct lawsuits. And now you want to protect the public interest? Yet through it all, Girardi's record with the State Bar of California, the government agency that regulates attorneys, remained pristine. It's literally all you need to know. I'm going to put this link in here, and then I will put it in the description as well so that you guys can read this whole article. It's fucking shocking. I saw it. So many of you sent it to me. By the way, can I tell you how much I love you, law nerds? When you're like, girl, did you see this? Thank you. Always send them to me. At me, DM me. I always want to see it. If you're like, you've probably seen this 100 times, it's okay. At me, DM me. I'm at the Emily D. Baker on the socials. Send it. Just send it. Because I see a lot, but y'all help so much. And I appreciate it. Here's the thing that pisses me off about these. A lot of these lawsuits timed out. And it feels to me, gut, female intuition, it feels to me that Girardi strung along clients, monuments to the gods of speculation. It feels to me that Girardi strung along clients long enough that when they finally plucked up and sued him, the courts threw the case out based on statute of limitations because he strung them along long enough that they couldn't successfully sue him. And that is fucking gross. So when we see articles from the Ruy Gomez family saying he said he was going to keep the money for us, he was going to help us with it, he was going to do this, he was going to do that, strung along and strung along and strung along. This article gets into how much money he has given to the members of the state bar, how he has helped people become judges, how much he has spent on political campaigns, all of it. But it feels like he strung clients along so long that by the time a lot of them sued, there was nothing they could do because the statute of limitations on this is short. So this article lays all of it out. Parties. Jay Leno performs at Tom Girardi's 2014 party in Las Vegas, where members of the State Bar Investigatory Committee were there. He booked Paul Anka and had judges, helped judges run campaigns, supported the governors. So let's get back to the State Bar telling us how much they care. Let's get back to the State Bar telling us how much they care. I'm sure there are those at the State Bar now who do not know all of what had happened, who are fucking horrified. However, organizations have organizational knowledge. Just like I can be like, I didn't know that. But if your corporation knows, you know. Why is he held in such high regard? Money, power, and he won some really baller lawsuits. And by all accounts of those who knew him, because I know people who knew him, and I know attorneys who had worked at his firm as law clerks, he was very, very charming. And then when the charm ran out, he was fucking scary and really politically connected. And I think people felt that he could bury them and bury their career. The LA Times article is very, very good. So the Office of the Chief Trial Counsel of the State Bar prosecutes attorneys for alleged violations of the RPC and the State Bar Act. The OCTC prosecutes attorneys to fulfill the primary purposes of discipline, which includes protection of the public, the courts, and the legal profession, maintenance of the highest professional standards, prevention of public preservation of the public confidence in the legal profession. Law nerds, there's over 4,000 of you. How are you feeling about the public confidence in the legal profession with this case? Because I have serious questions, and I am a member of the legal profession. And I know a lot of great lawyers, but this is fucking bad. It's fucking bad. Following hearing, the State Bar Court may recommend to the California Supreme Court that an attorney be suspended or disbarred. The State Bar and state agency is an interested party with standing to object to the petition. The State Bar's imminent charges against Girardi allege misappropriation of client funds. Oof. No shit. OCTC is poised to file disciplinary charges against Girardi, alleging that he willfully misappropriated clients' funds and refused to obey a court order. Lawrence Declaration 1. Girardi has not asserted that he lacks capacity to participate in the State Bar proceeding. In fact, even after this court issued a limited temporary conservatorship on February 2nd, Girardi continued to participate in the State Bar investigation, including on March 5th, when through counsel, Girardi requested to participate in a pre-filing settlement conference before the State Bar judge. That is tea. That is tea. Yes, granted. Who made the motion? Somebody made a motion. I saw the motion in the chat. Motion to change the colors. Jacob, motion granted. We're going to red. We're going to red. Let's change it. All right. Red. Ready, red, red. Ready, McRed. This is going to get a whole separate video at some point. So you guys are getting the preview because there's some tea. There is some tea up in here. Yay. The state bar has valid reason for concern, again, that this conservatorship proceeding may interfere with the state bar disciplinary process. You could have done it sooner, though. Like, years ago, given the legitimate questions regarding the veracity of the petition, that the serious consequences would result from an inaccurate finding, further inquiry by this court is necessary. So they're asking the court to do further medical examinations. The unusual timing and circumstances of the petition also call for further inquiry before deciding whether the petition has established by clear and convincing evidence that a conservatorship is warranted. There are facts not yet before the court that are relevant to the capacity determination. So the state bar is saying we have more information. Let's see what the state bar has done. On December 10th, 2020, OCTC sent a letter to Girardi informing him that he was under investigation and requesting a response. On December 14th, a U.S. district court entered a $2 million judgment against Girardi and froze his assets. That's the Lion Air case in Illinois. That's the judge that's the honey badger. He's like, I don't care who the fuck you are. We're not doing all this. On December 15th, the Los Angeles County Superior Court Judge Holly Fuji issued an order to show cause why Girardi should not be reported to the state bar for misconduct and violations of the RPCs for withholding settlement funds from plaintiffs that were required to be maintained in Girardi Case's client trust fund account and distributed in a timely manner to plaintiffs on January 4th, 2021. The judge stated that she would report Girardi to the state bar in the Rui Gomez case. That's a case where the Rui Gomez family is owed $11 million. There's a settlement in that case in the bankruptcy court, by the way, that just happened, or a proposed settlement. On January 15th, 2021, the state bar sent a letter to Girardi informing him that it had received and complied with an investigation requested by the U.S. bankruptcy trustee for Girardi's client trust account records. Just days later, on January 19th, the instant petition was filed. The surrounding facts and circumstances should at least be examined more closely. Sus is what the state bar is saying. The capacity declaration of Dr. Nathan is materially incomplete and lacks necessary information. Ooh, sus. He opined that the conservatee has major neurocognitive disorder. Another material admission from the declarations is a failure to state facts to support the assertion that Girardi is purportedly unable to attend the court hearing. Dr. Lavid checked the box to indicate that additional facts would be provided in attachment 5, yet did not submit the attachment. The doctor did not answer the question on page 1, asking whether Dr. Lavid is currently providing him treatment and care. Additionally, the minimal declaration lacks necessary information. Yeah, we don't think it's good enough. The court should order a neutral medical evaluation, not that doctor. And then there's a whole declaration. And we're going to go through that. Not super long. We'll go through some of this more thoroughly in a separate video. I'm informed and believe that on December 10th, the State Bar of California sent a letter to Girardi, and he started complying with it, and he started working with the State Bar. I'm informed and believe that on March 5th, OTC notified Girardi's discipline defense counsel, because when you are, being investigated by the State Bar, you have due process, and you do have a defense attorney to represent you to the State Bar. Of OTC's intent to file disciplinary charges, and informed Girardi of his right to seek pre-filing settlement conference pursuant to Rule 5.30 of the Rules of Procedure and the State Bar Court, at which a State Bar Court judge gives the parties an oral evaluation of the facts and charges and allows the party to attempt a resolution. I'm informed and believe that the same day Girardi's defense counsel replied and requested a pre-filing settlement conference. So he's actively trying to cover his ass to the state bar, but he can't proceed in the other. And there's a YouTube video. Ha! It all comes full circle. Yikes, you guys. Yikes. That's going to get a whole video at some point when we do an update. This is wild. What has also happened is that we learned in the bankruptcy court that the cars are leased, like one of the cars, the Aston Martin and a Land Rover are leased. And so the court is like, give the leases back, that he is going to have to move out of his house. It is being prepped for sale. So he's going to have to move out when it goes into escrow. His brothers argued he has nowhere to go. And they're like, we're putting it up for sale. And now there is a proposed settlement with the Ruigomez family in the bankruptcy court, which is the bankruptcy for Girardi individually. So everything that gets sold, a lot of it's going to go to the Ruigomez family, not all. So there's not going to be anything left in this personal estate for the divorce, as I suspected earlier. How Erika is paying for her rental and things like that. It'll be interesting to find out when she eventually gets dragged into all of this, because she has not appeared in the bankruptcy court and she's going to have to. This is y'all. The state bar, will the real state bar please stand up? They finally stood up. They suspended his license. It's late. It's late, but I'm glad to see them objecting. They're going to fight the conservatorship. Okay, state bar, I see you. Lay it out, because the LA Times has laid out quite a lot and makes you look like you have done nothing. So we need to know. I'm excited to see the state bar get into this. This is going to be fucking messy. I'm very concerned that current clients aren't going to get their money. I'm very, very concerned. To the gods of speculation, can we say EJ has been or trying to cover for Tom Girardi because he has never read her cat's contract on I don't know. Maybe. And I remember that when he didn't read through it. I don't know. Maybe. It's interesting. Can Girardi clients go after Cal Far for not handling multiple complaints about Girardi going back decades? Snowcat, I'm not sure yet. I'm looking into it. I don't have a clear answer on that yet. It's a regulatory agency. And so going after a regulatory agency for not doing their job is difficult. But it's absolutely something I'm looking into. When I have an answer, I will let you know. I just don't have an answer yet, and I'm not going to speculate on it until I have an answer, because I never even thought that far ahead, because I never even thought that the state bar would fall down like this. Oh, okay. We need to go to questions, because we're getting into questions, and then it makes it easy to timestamp. So we went into questions a little bit. Questions. I'm shocked by all of this. I think we just need a full Girardi update. But here's the most interesting things. The cars were leased, which I was surprised by because they floss pretty hard. He's going to have to move out of his house. He cannot practice law and has been temporarily, rendered ineligible to practice law. The state bar is objecting to the conservatorship. The bankruptcy court is coming in hot and going after all of the money, and there probably isn't going to be anything left to divide up in the divorce. I mean, there's not going to be anything left to divide up in the divorce. What else was going on in the bankruptcy? Those are the big ones. So, and the settlement with the Ruigomez family. It looks like there is a proposed settlement where we're going to sell this and this amount of money will go there, and the creditors have time to object. So we will see. What we haven't seen, Erika Jayne defaulted on appearing in the Illinois case with her company, EJ Creative. Remember, in the Illinois case, they said that EJ Creative took a $20 million loan from Girardi Case. And if that's true, the bankruptcy court will try to track down that loan. The bankruptcy court, as to Girardi Case's law firm, has said it's going to take them at least 6 months to do the accounting. The bankruptcy court for the personal bankruptcy is now saying, it binged. The bankruptcy court for the personal bankruptcy is now saying that they are going to need time to, they are going to need time to do an accounting because Girardi is supposed to submit accounting to the court and has not done so. Yes, we need flowcharts. We're going to have to do that. Not this round, Wendy, but I am working on it for a future collection. So not this round, but I am working on it. My distributor right now, some of the glasses are getting broken when shipping. So we're not there yet, but yes, it will happen. What legal recourse do current past clients have if they haven't been paid their settlement? Ooh, they have to talk to an attorney. I'm sorry too, Siri. They have to find another attorney to take up their case and then figure out how the case is. So there is a lot of different possibilities with this. If somebody is not gotten settlement money, then the bankruptcy trustee is the person they need to reach out to saying, hey, we had this settlement that we didn't get either, because they're still going through the accountings and people are going to come out of the woodwork. If they are still in litigation, they have to find new counsel, and that new counsel is going to have to work with the bankruptcy court because the work Girardi has done becomes bankruptcy funds. It's a fucking mess. So they're going to have to try to contact the bankruptcy trustee and then try to contact an attorney. That is the best info I have on that. I am not following this right now, but it is something that is coming up more in the news, Kathy, because there's one going on in Utah too. So I put out a poll for questions and we will do my best. I will do my best. Thank you, Diva. Yes, please. I'm blown away by this, but I'm glad the state bar, today the state bar stood up finally. We'll see what happens. Thank you, Jakes. Appreciate it. You guys are welcome to go ahead and smash that like button. We're at 90.8, you guys. I'm shocked. It is awful. I didn't mean to flash off of that so fast. It is. I am what I am said. This is awful. There are no words. I'm heartbroken. I'm heartbroken for the clients involved in this. No, everyone deserves good legal representation. It doesn't matter who the person is. Everyone deserves good legal representation. Bad lawyers make me mad. And this isn't just careless. This is criminal. And it's thousands of people. It's thousands. Don't say sorry. Politics money and lawyer money in this case is sickening. And it's why it went on for so long. And it's why money in some of these institutions can become a huge problem. You know, it's like trying to have government regulate tech. There's too much money for that to happen. And it's why tech, I'm not going to tangent. I'm not going to tangent. I mean, I don't think that's going to happen. Dinner's ready. I think if Brown was trying to do that, there's a different way to do it. But riling Saltsy is maybe not the way to do that, because I feel like he's going to create a personal vendetta from Saltsy, who's like, fuck it, I will ride till the ends of the earth to finish this case. So I don't think it's a good tactic. Also, you don't put your professional life. You can advocate for your client. You can vigorously represent your client without putting your own license on the line. Yeah, that can be done. It's regularly done. I don't know what Brown's doing. Yeah, the bar is going to have to answer some questions to somebody about how this went on so long. And they, the people who were involved in this article from the LA Times are gone mostly. So it's looking back and looking forward, I think. How much is the house worth and how much is it mortgaged? It's mortgaged for well more than it's worth because it has multiple mortgages on it. And it's also promised as collateral to multiple people. So I believe the house is worth in the $20 million range, and it's mortgaged. A, it's mortgaged past that, and B, it's used as collateral. So it's going to be a problem. Is the state bar doing anything to sanction other attorneys at Girardi Case for being complicit? I have no idea if other attorneys are also going to be audited. They could be. I mean, the other, two other attorneys, Lyra, his son-in-law, and Griffin, have been called to be questioned in the Illinois case. So there are questions being answered. But at the end of the day, Girardi was the only partner. He said he was the one in charge of the money. But now we've seen that Griffin and Lyra had some signing authorities. So yeah, it's definitely going to come up. Will they do that? We don't know, but we'll see. Isn't Erika responsible for Tom's debts? The personal ones? Yes, she is. Which is why the divorce proceeding in, my words have gotten challenging, in the Illinois case with regard to the Lion Air crash, when the other law firm filed that suit, they said that they believed the divorce was a, quote, sham divorce in their filings because they thought she was trying to sever ties, like from the date of separation in California, your debts are yours, my debts are mine. So they said it was a sham because she's like trying to sever ties so that the debts from that point forward wouldn't be her problem. I don't know how much that's going to fly because in the bankruptcy court, a lot of this stuff is going to go. And if her company does owe Girardi Case $20 million, then she's going to owe the bankruptcy court $20 million at some point down the line because the bankruptcy court might go ahead and sue her for that. So you're welcome, Pink Supergirl, who said, I'm so glad Emily D. Baker is unbiased and fair. She doesn't throw hate or judgment at people like so many others. I will tell you the things that make me mad when they make me mad, but these are all people that we're talking about. And at the end of the day, we're here to talk about the things that were done. But this is also something, look, I share a lot about working as a DA. It was my career. It was over 10 years of my life, and it's something I feel very strongly about. But I always told juries when I was a DA, we are here to judge the actions of the person sitting here on this day. We are not here to judge this person. Like, we're not here to judge defendants. Were there a few defendants where I was like, I cannot? Yes, there were, but that's my personal belief, and it goes to the side. The jury was not there to judge the defendant. They were there to judge the actions on the day based on what the witnesses and victims said and decide if those actions on that day were this crime. That's what it is. These are the facts. This is the law. What do you think? And that's what I try to do here. These are the facts. This is the law. What do you think? And when I don't like the facts, I will tell you, I don't like these facts. All of this shit, I don't like it. I am heartbroken for the clients that are involved in this. We don't know why this started. We don't know what is happening. What we do know is what it looks like. And with Girardi, it looks bad. And the state bar hasn't done shit. It makes me mad. We don't know what Erika knew. We don't know what she didn't know. We'll figure it out. At some point, more will come to light. And we'll go from there. So I do my best. Trisha A said, now that it's half done, have you watched any of the Chauvin jury selection? I have not. I'd love to hear your perspective on the line of questioning of potential jurors. I have not watched it yet. I've been very deep into this stuff, but I will, when I catch up on it, if I have thoughts, I will share them. Little Red Star, could a whistleblower at the law firm have gone to the DA with all the questionable stuff that was going on? Because it sounds like embezzlement. That's a good question. Could a whistleblower in the firm have gone to a district attorney? Yeah, I mean, they would have had to have gone to the police first. They could have gone to the state bar. We don't know if that was done or not. We really don't have those facts. Things could have been done. There could have been people in the firm that saw things and said it. That's how the IRS gets a lot of their cases, from whistleblowers inside of for investigation, whistleblowers inside of businesses and jilted spouses. When I worked at the U.S. Attorney's Office in their tax crimes division, the IRS agents I worked with were like, no, this is where a lot of our cases come from. Insiders in business and jilted spouses or lovers. So could people have done it? Yes. Did they? We don't know. We don't know. Question, what will happen if they find out he's faking it? Well, that would come into question for the doctor, and it would be a problem. But I think it's not is he faking it? I think it's going to be, is there enough for the conservatorship to be granted? Will they investigate if I mean, I don't know. There's so much shady shit that seems to have gone on. Will they investigate him if he seems to be faking it? Yes. I mean, there's already a state bar investigation and criminal investigations going on into this. It's going to be bad, but he's also 81 and there's not going to be any money left. So what do you do? Like, what's going to be the real consequence to him? He's lived an entire life, it seems, jetting around doing what he wants, living in a palatial mansion in Pasadena, living his best. He's 81 and other people are going to be left to pick up the consequences. He's not going to be picking up a lot of consequences. Yes, at 81 years old, he is going to be embarrassed. Okay. Well, yeah, you're embarrassed. And you're not living out the rest of your life in your palatial estate. But what's been done to others is so much worse than that. The consequences for him, do I think he'll ever see jail time on this? They might sentence it. Do I think he'll ever actually put his ass in a jail cell? I don't know. This is going to take a lot of time, and he's 81 years old. Question, what do you think the state bar would do about the Britney Spears conservatorship? They could make the same parallels. See, the only reason the state bar cares is because the state bar wants a piece of Girardi. The state bar wants to investigate him. So the state bar isn't involved in the Britney Spears conservatorship at all. And it doesn't seem that the attorneys in that case have done anything improper. The federal government's apparently interested in the Britney Spears conservatorship because it seems that members of Congress are asking for an inquiry into it. But the state bar is not a related party to that because Britney's not an attorney. Can you review what's going on with Dr. Dude's divorce? Who is Dr. Dude? I have no idea who Dr. Dude is. Jen Hobbs says, I am speechless and my heart hurts for all those people. Yeah, thousands of people. I'm kind of pissed that nothing was done sooner. Oh, beyond kind of pissed, Jen. I'm beyond kind of pissed. I'm outraged. Like, I'm mama outraged. It's beyond lawyer outrage. It's like mom outrage. How dare you do this to these people? Outrage. Outrage. If he passes well in the middle of it all, can they go after his life insurance? Yes, they can. It would go into the estate. That's a great question. Question, can Erika be held responsible for Tom's unpaid debts? I think I answered that before the time of separation. Yes, if they find that this is why the stuff matters. Oh, Dr. Dre's divorce. I don't know much about what's going on in Dr. Dre's divorce. I will ask if everybody's interested. I've definitely put it to the channel members to kind of help pick what we're going into next because there's so much and I'm me. Question, if a previous client wanted to reopen their case with him because of his misconduct, would it be a lawyer represent Tom or his firm? Stephanie, I don't quite understand what you're asking. I think you're saying if a previous client wanted to reopen their case with Tom, there are so many factors that depend. If somebody that was a client of Tom Girardi has concerns, they need to reach out to a lawyer and have a consultation to ask what their options are. Because there's going to be a lot of questions. So, Casey says, just moved to my own apartment. It gets a little scary at night. These long nighttime chats are so helpful. So glad I found you, Emily. Casey, I get you. I feel you. There are still times when it's weird being in my house, like when my husband travels. And since we've moved, that hasn't happened. We normally travel together, but like when the kids were little and stuff, I would literally have nightmares. I'm like, my husband's out of town for work, or mostly conferences because he didn't really travel to work. It was for education. But like, what if I fall down the stairs with my two kids at home? What if something happens to me? What if I have a heart attack in my sleep? Oh my God, I'm going to die. I'm going to die here alone. And my kids are going to find me. And I would have nightmares. Is Dr. Badass going to make an appearance tonight? Frank, no, he is at swimming with the kids. They will actually be home pretty soon, I'm sure, but he was at swimming with the kids. I'm going to get to a few more questions. Thank you. I will let him know, Lauren, that you have super chatted for him. I will let him know. I know. I can't believe it either, Diana. Um, I, s- I always picture Brown as a middle-aged, badly dressed man with his papers all over the place. Someone last week said his office was smelling old. His picture's on his firm's website if you guys want to Google him. I'm sure it's on LinkedIn too. Thank you. If Erika files for bankruptcy, can she keep the housewife's paychecks? No, it would all get swooped up into the bankruptcy, except for living expenses. Question, why is the bar not raising these same arguments in the conservatorship against Brittany? So I think I answered that well. Thank you so much. I love telling the stories. Lisa said we love hearing the stories. I love telling the stories. I try to remember to talk through the questions, and sometimes I start moving fast and I forget. So for all of you just listening, I try. Sometimes I forget. Question, how did the Girardi case not get media coverage until now if it had been going on for decades? Well, a jaded person of 30 years, the house of cards just fell. I think this was an open secret within the legal community. I'm not part of the plaintiff's bar. I've never worked in that area particularly. But from everyone I've talked to, it seems that there were rumblings of this, but that he was well respected. He was still getting awards from all of the like big bar associations. He was kind of a gatekeeper. He was a gatekeeper to the nomination committee of who became judges. So people were afraid to speak out against him. And a lot of those cases and lawsuits that were brought were dismissed. And, you know, attorneys tend to believe other attorneys. If it's like, oh, that was just a disgruntled client. Oh, that was just this. Attorneys aren't really asking that much about it because he's one of theirs. So is there a problem with law being like an old white dude club? Yeah. Do they know each other? Yeah. And that article on the LA Times really points to some big questions of corruption and the fact that he was so well connected. So that's why it's being linked. I'm sure Tech, because she's amazing, has already linked that in the description if you guys want to read it. Would you ever do a prosecutor reacts to a TV show? Yes. I'm desperate to see how you react to an episode of SVU in which a biased judge refuses to recuse himself. At some point, I absolutely will do that. Yes, yes, yes. I want to know where the money went to, Leanne Norman. I don't know. Question, are the companies that paid their claims to Girardi also involved in the lawsuit? No, because Girardi's the one who misappropriated the funds. So there's that. Lauren Cup said, Mom can't be the only one getting super chats. I appreciate that. Anna says that the case is so depressing. Yes. Yes, it is. The Girardi case makes me deeply sad. Deeply, deeply sad and frustrated and angry. And I feel very badly for the clients. Like, I'm very frustrated by it. With the Tati case, like, I'm frustrated by the ship Brown's pulling, but that case is entertaining as all hell. It's going to be stressful for the parties involved, but for all of us, it's like, ooh, tea. The Girardi case is deeply, deeply disturbing. And yeah, it's one of those like question your faith in humanity type of cases. Question, if he is found incompetent, can Erika be liable for not getting him help? I don't think so, especially if they blame the Alzheimer's for his actions. I would have to think on that. I don't think she's obligated. And if she was obligated, I think she'd be covered by spousal privilege. The attorneys at the law firm might have more obligation than his wife to do something about it. And also spousal, I think a lot of the spousal, like, they can't call her and make her testify, be like, did you know that your husband was still taking clients and had Alzheimer's? And even the state bar is like, look, 3 months ago, he was holding meetings. So the state bar thinks it's sus. Question, Emily, do you actually have time to sleep at night? Not enough. Can you tell? It's like, it's not enough. I have not been. I'm fascinated by this. I love what I get to do here with y'all. I have not been sleeping enough. It's on my list. Next week, we have some time off. It's spring break. So I will be catching up on stuff. I think we've talked about what happens if Girardi dies. The money, look, bankruptcies run like an estate, so the money just goes into the estate. Have you covered or will you cover Here for the Tea versus Trend Mood? I have not covered it. I have the complaint. I have not read it yet, so I'm going to read it and see, but I asked the channel members what they thought, and we'll go from there. I know people are interested in it, and I know that Truth Sleuth had done a video on it. I don't know if she's going to do another video on it. I want to see what Here for the Tea says about it. She indicated she was going to speak about it. Petty Page just did a video about it. If I have anything to add from the legal side, I will. If there's not much to add to it, I don't know Here for the Tea or Trend Mood. I don't know their content. I don't know any of the backstory. So it would, if I break it down, it would just be breaking down the document and what I think. But it looks like it's also a defamation case, which might be an interesting juxtaposition to the KJ Tati Westbrook case. I just know way less about those two individuals. Literally nothing. In regard to the KJ Tati Westbrook case, do you think Brown could be a personal friend of KJ's, and that's why he referred to her as my Katie? I have no idea. Anything is possible, isn't it? But also, how do you have a personal friend who's an attorney in Washington? You've never been to Washington. You have no connection to Washington. I have questions. Could it be? Yes. Could it just be a typo? Yeah, it could. I don't know. Yes. You guys, I'm going to answer a few more questions and then we're going to do court of public opinion. I'm kind of shook by the state bar coming in hot. Like when I went in today before this to download stuff, I was like, oh, there's an objection. T. So I'm going to have to do a whole video on that. Is it possible Erika didn't have a clue? Yes, it's possible. Yes, it's possible. I'll be very interested to what she says on Real Housewives. I'll be very interested to what she says publicly. And then I'll go from there. But for now, I know people are like, fuck you, Erika. I understand the emotion, but I don't know what she knew. I don't know when she knew it. Oh, for sure. The question from Lindsay is, I wonder if the IRS is going to investigate the Girardis. Yes. And actually, the state of California just levied a big tax bill against them. So, the tax consequences are coming. I don't know if there's going to be any money left for that, but the tax consequences are coming. Question, do both Loriannes work for Dot or whatever, or just got the wrong Lorianne? We don't know. All that's been said is that Lorianne worked for, I think the language was government agency, but it wasn't ever said where the real Lorianne works, and I think that's probably a good thing. Okay, we answered that. No. Oh, Deb F. No. If Girardi dies, this is not all null and void. It all stays in the bankruptcy. So it just goes into the bankruptcy estate. And if there's liability to Erika because she's the spouse, that keeps going. So no, if he passes, then it will continue to go. What will stop is the state bar investigation and any criminal investigation, because you can't punish a person that is not physically on this plane of existence. But the money stuff will continue. The money will go on. The money will go on. And that was My Heart Will Go On. But then I was like, I am not capable of singing that well. Question about the Tati case. What's the point of Brown filing new stuff if all the facts go to Tati's side? It's a brilliant question. He's mad at Salty. He's running up litigation cost. He thinks he has to. I don't know. Wouldn't he be able to defend KJ's side if jurisdiction is confirmed? Yes. Those are all very good questions. See, the reason y'all are feeling confused is because the shit that's happening makes no sense. It's not that you don't understand. It's that it doesn't make sense. So yes, Anna, you're exactly right. Those are great questions. I'm going to take just a few more. You guys are asking great questions. I appreciate you so much. And then we're going to go to court of public opinion. I have followed you for a while and just wanted to say that you inspire me to keep going. You're welcome. Keep going. There's a lot that, yes, thank you. I love the red. Is that bad? It's not bad. We're getting used to it, aren't we? But the state bar showing up is definitely a whole DEFCON red level. Could they keep, question from Lauren M. I love your BB-8 picture. Oh, and it looks like Ray and Kylo are in there too. Could they keep bringing you up in the KJ suit because they know you won't freak out by being mentioned in legal documents like a layperson? Well, I have no idea why they keep bringing me up. They're trying. That's not true. I think they're trying to say that part of the sanctions, like part of the impropriety, is that there's like this desire from Salts to like use channels to like spew information everywhere. But I'm like, we're reading documents up here, people. And commenting on them. They're public records. So I don't know why they want to, but whatever. They're going to do what they're going to do, aren't they? Ridiculous question, mostly for your reaction. I also asked Civil Law, if KJ fired Brown and called you, would you work for her? No, I would not. Why? Because I have already A, been named in this case. B, I'm not licensed in Washington. C, she came for me on Twitter. D, I don't do litigation work anymore, though I am a very entertaining trial attorney. D, I like doing legal commentary, and you can't pay me enough not to do that. So those are all the answers, Frank. We have Frank, and Brett. We got all the names in here tonight. I appreciate it. Question, in Canada, the government always gets paid first. Is that how it works in the US? A lot of the times. Like if there are tax liens, they're going to get paid first, if that's what that's referring to. So I missed a few super chats. I'm going to make sure I get those. And then we're going to go to court of public opinion because I'm very excited to get to court of public opinion. Yes, it is. It is COPO time. I love court of public opinion. Question, can you please cover the lawsuits of a woman of color against California for first? What? I have not even heard of that. Forced sterilization? I mean, I'm going to write it down. I'll watch the thing and tell you my thoughts when it is time to tell you my thoughts. Because if there's lawsuits, you know I'm there. But that, I had not heard of that. So we're writing it down. Because that's how we remember things. I got a new cover for my notepad, and it has made me so happy. I'm a total convert to these. I'm a total convert to ring bound. I'm a convert. There, I said it. Sorry, full focus planner. I'm a convert to ring bound. I'll talk about my planners another day. If jurisdiction is decided and not being Washington, then Brown will be out of the picture. Yes. So KJ will need a new lawyer in Minnesota. Yes. So everyone should go ask Nick Rekieta if he would take the case. He's in Minnesota. Go ask Rekieta. Serenity asks, if it is found that Girardi has Alzheimer's for a while, what would that do to all the cases he was involved in? It would be a mess. It would be a mess. How they would unwind that, I don't know. But it would call quite a lot of things into question. He's also gone on the record like defending himself in other cases. It would be a mess. Do you think the court would hold Brown in contempt for the filings? I don't know if the court will bring a contempt motion on their own. Could I see a contempt strong? I think there would be warnings before that. This judge seems to be like, I trust you, don't fuck it up. There would be warnings before that. Could it happen down the road? The court can always hold people in contempt. They normally will tell you and order you to not do something first. And they would say, don't do this, don't do that, what have you. Could there also be a sanction? There's a lot of what could happen. There's a lot of shit that could happen still in this case. So we'll see. Okay. Rekieta won't touch this with 30 cattle prod. No, he wouldn't. No, I don't think he would either. If you like ringbound notebooks, you should look at the William Hanna notebooks. I will absolutely look at that. I've never heard of those before. I like Tool Rocks. I like their pens too. I use a lot of Flair pens. Question, could we get a ranking of the motions legal issues you cover in their respective DEFCON levels? At some point, I will do that. It would take a little work to go back and reflect because some of them we didn't have the ranking system yet because this has all been growing together. Listen to Serial and talk about it based on the podcast and the new information that's come forward since then. That's a big time ask, Nicole, but It's been on my mind. I just don't know if we will have time. Do lawyers have to go through any mental evaluations to continue practicing? No, they do not. They have to go through continuing legal education and different kinds of trainings, but no, they do not. It's generally like, if you can't do this anymore, you need to not. Paul, I'm going to talk about that at some point, I'm sure, with Adam on Up and Adam. I need to see what happens in this season before I decide. How does HIPAA interact with these medical filings in both cases? Because they are court cases, some things will be under seal, some things can't be disclosed, and some things must be disclosed. And I believe there are HIPAA exceptions with regard to court cases. But that said, I have been talking for 2 hours and 15 minutes, and we still haven't gotten to court of public opinion, and we have to do that now. I am not taking, even if you super chat me, I'm not taking more questions. Don't try to distract your girl. I love you, but you know I'll get distracted. You know it's true. Court of public opinion. I like the jam for court of public opinion. I love that intro made by the amazing Tech Valor. My family has been playing kind of a new kind of a game. Sometimes it's kind of savage. They're rough with me. And it is, you could only have one. And we generally play it in the car. And the other day, my kids were like, Mom, you can only have one forever. Starbucks or what was it? Starbucks cups or, gosh, I've totally blanked. What was it? It was, you can only have one. Starbucks, anything from Starbucks, cups, food, drink, or Apple products. Which is it? And it was hard. And I was like, we need to do just one for court of public opinion. So Travis's question was not this. Travis's court of public opinion had very much to do with his with his classmates and whether you can have a real relationship in junior high. And I'm like, buddy, we're not even going there. We're not polling the court of public opinion because you want to tell your friend that his girlfriend's not a real girlfriend because all they do is talk in the hallway. We're not even going into it. So tonight, I'm not going Starbucks Apple to y'all. My kids did that to me because I'm a fangirl. So all you Samsung people are going to be like, forget it. This is easy. I'm going to make you pick one. We're going back to the world of food. So for the court of public opinion, you can only have one condiment. Here are your options: ketchup, mustard, mayo, ranch. You get to keep one. What is it? What do you keep? Mustard, ketchup, mayo, ranch. One condiment to rule them all. I know this is a very American list. I do not have Vegemite or Marmite or fish sauce. I know it's a very, very American list. I am very American. We'll have to do an international one as well. This one I think is going to be all over the place. Y'all, my people. Ranch. Me too. Mustard, ketchup. So the reason there's only 4 is because I can only put 4 on the poll on Twitter. And I learned that the hard way with the Batman question. I didn't realize I could only make a poll with 4. Mayo, but only from the Netherlands, not this American crap. It's a very fair point. Not all of our mayo is good. We have some very fake mayo here, which is why we all like ranch so much. Ranch, ketchup, mayo. Mustard might be the outlier from the chat so far. Mayo. Motherfucking ranch. Literally no ranch? I'm shocked when people are like, I don't use ranch. Mayo, ketchup, ranch. Need more ranch. Always need more ranch. I'll have to tell on Tuesday. I will tell you the need more ranch story. It's a high school story, but I'll tell you the need more ranch because my friends and I used to, yeah, we have ranch problems. Ketchup, ranch, ketchup. Don't like condiments. It's fair to not vote. Ranch, mayo, mustard. Here's the mustard crew. You guys, mustard takes longer to type. It's clear. Amy's with me with ranch. I'm a ranch girl. Mayo, ranch, but I love mayo. But I'd put ranch on a sandwich. Like if I had just one. But I don't know what I would put on meatloaf because it needs ketchup. But it needs ketchup. It needs ketchup. I'm not a ranch girl. Don't like it, but have been don't like it. Don't been have any in my house. Fair enough. Wait, ranch is a dress. Ranch is a condiment. Ranch because Midwest. Garlic mayo. I mean, which is almost ranch. Ranch, but not organic ranch. No, it needs to be like real good ranch. All of the sauces. You can make ranch with your own mayo. Also fair. Ketchup. See, here's the thing. It would be hard for me because hot dogs with mustard and onions are the greatest. Like it is one of the greatest simple pleasures. Dry ranch dressing in the meatloaf. Ooh, that would be good. We have dry ranch dressing here. Mustard is second. Aioli is my favorite. I mean, it's fair, but then you go with mustard or then you go with mayo and you make your own aioli, right? Mustard, ranch is its own. I saw somebody say ranch is its own food group. I love that. Mustard, spicy mustard, honey mustard, yellow mustard, all of the mustard. Not ranch because Midwest. It's overdone. Mustard all the way. You guys have this is going to be a close one. Here's my reasoning. Ranch can be used on hamburgers, chicken, salad with veggies. Hot dogs can have cheese, but who would live without a bacon ranch burger? This is a very, very good point, Knit with Brit. I could use ranch for everything. Chicago-style hot dogs all day, mustard, onion, pickle, tomato wedge, and celery salt. That's a whole lot on a hot dog. I'm a basic bitch. I'm like hot dog, mustard, onion. That's it. That's not true. There's a hot dog place in Nashville called I Dream of Weenie. It's as good as it sounds. And they do make hot dogs with macaroni and cheese on them. It's amazing. And it's amazing. So I could live maybe without mustard on a hot dog if I could put mac and cheese on it. Garlic mayo is not ranch. What is ranch? Is ranch America's version of aioli? So ranch is kind of a salad dressing, but it's also a dipping sauce. It is a condiment. It is delicious. It is not always as well. Some of them are as thick as an aioli, but it's a whole thing. So kind of like an aioli, but we also have aioli. Ranch is its own category. Okay, now you're going to make me go eat something with ranch. We had wings and ranch last night. It was very good. Ketchup, fries, eggs, meatloaf, all the meats. I get it. I get it. Tomato sauce in Australia. I mean, that would be, in this poll, it would default to ketchup, right? Mayo for sure. How about vegan mayo? I've never tried vegan mayo. I don't know if that would be good. 3 mustards, 2 ketchups, 1 ranch. Thank you for the entire house vote. Mustard wins in your house. Your ranch vote is going to be sad. Because if somebody was like, you can only have mustard, I'd be like, no. Runny ranch. TJ, it's a very, very fair separation between the two because there is that thick ranch and runny ranch. Meatloaf can take barbecue. Elizabeth, this is a great point. You can put other shit on meatloaf. Mayo, because you could do more. Fair. You could make mayo into ranch, but I rather just have ranch. Mac and cheese with pulled pork in a parfait glass. Ooh, that sounds delicious too. Now I'm getting hungry, y'all. See, I don't consider butter a condiment. I guess it is a condiment. It's just such an ingredient. In the sauces, I never really contemplated butter to go in with the sauces. For my categorization purposes. So eat Dijon straight. That's hardcore, Anika. I don't think I could do that. Ranch on meatloaf would be fine. It would be fine, wouldn't it? Brown sauce on sausage, eggs, chips. What is brown sauce? I have questions. What is brown sauce? Hot dog, mac and cheese, and ketchup. So good. I had never even thought of putting mac and cheese on a hot dog until we went to I Dream of Weenie and they put mac and cheese on the hot dogs and it was so good. Hello, Jamila. Good to see you. Regular ranch, but not like buttermilk. Oh, no, not like buttermilk ranch. No. Agreed. Yes, with the buffalo ranch. My answer used to be mustard, but 10 years ago, I suddenly became allergic. That's a bummer. I hate it when that happens. That's not a unique experience, but it's always such a bummer. Barbecue on meatloaf is freaking delicious. There's a million ways to eat meatloaf. We love meatloaf around here. I really do like meatloaf quite a lot. If anything, it's its own food group. It's butter. I agree with that. Butter is its own. I don't put butter as a condiment. I really don't. I put butter as a ingredient. Butter garlic sauce. Yum. Oh, I love buttermilk ranch. Well, there you go. I only do French fries with ranch. Well, I do quite a lot of things with ranch, actually. Brown sauce is not gravy. What is brown sauce? So confused. I need to know. I'm very under-traveled. I spent way too much time in school. And even in college, I spent time playing water polo. And then I was just doing school. So I have spent too much time. Explain what ranch is. I think I did. I think I explained what ranch is, but it's like it's a mayonnaise-based dip or dressing that has a particular ranch flavor. How do you explain ranch flavor? Kind of like Cool Ranch Doritos. But if I have to explain ranch, I probably have to explain Cool Ranch Doritos. Speaking of which, do you know they spell spicy ranch Doritos? I had no idea. So I thought I bought Cool Ranch Doritos and then they were spicy ranch Doritos. I was very, very surprised. They were not Cool Ranch. They were spicy ranch. So it's seasoned. It's like a seasoned mayonnaise-based dip or dressing. So it's used for dipping fries. It's used for dipping food. It's used to put on sandwiches and hamburgers and all the things. And it also seems to be kind of regional to different parts of the US where ranch is more favored or less favored. So, yep. Well, there we go. Thank you all for defining ranch. Hidden Valley Ranch is the definition of ranch. It is. It's the OG ranch. It is. It's the OG ranch. So, dill and other things. Brown sauce is A1 sauce. Oh, well, that makes sense. Or HP sauce. Okay, I know what HP sauce is. I know what A1 is. That makes sense. But I've only been to London once, and I did not have all of the time to explore because I was at a conference. Thank you guys for explaining brown sauce. See, I love our international audience. We'll have to do an international one too. This one is I get it. It's very US centric with the sauces, but we will have to do one with, Marmite and Vegemite and brown sauce and all the things. But you can always leave it in the comments. You guys, it is time. It's been 2.5 hours. I've talked a lot. A lot has happened today. A lot has happened tonight. I'm hungry, a little bit tired. I love all of you for being here. I'm going to put the poll up on Twitter and I'll put the poll up on the community tab here on YouTube, which I didn't realize was not accessible from iPads, but there it is. Whoop. And we're going to keep the food fights continuing and then we will shift. We will shift to another topic for Quarter Pub Opinion next week. I will be on the YouTubes on Tuesday for Court of Public Opinion. Until then, if you want to see the new family members that are coming home tomorrow of the four-legged variety, you're going to have to follow me on the Instagram. And if you're not on the Instagram, I get it. If you're in the text crew, I will send text crew stuff. Otherwise, you're going to have to wait till Tuesday. So I might post on Twitter as well. Okay. Follow me on the social you follow me on. I'll be sharing tomorrow, mostly on Insta. I will share a picture to Twitter and to the text crew. I want to make sure everyone's included, but I'm not going to be on the YouTubes until Tuesday for Coffee and Cursey Words at 11. I can't imagine anything's going to pop off. I try to keep you posted when shit goes down, but also it's coming up on spring break week for my kids and we've got family things to do as well because I like hanging out with my kiddos and my husband. I think we're also going to do 17 log offs. I think we're also going to do a episode of the Emily Show that's like a COVID retrospective from the California lockdown to now. And I think I'm going to see if Dr. Badass will be a part of it. I'm going to try to convince him to do that episode with me. So there might be a joint episode with me and Dr. Badass. I will share the new four-legged kiddos tomorrow. I'm reading your chat and misspeaking. The kids that are coming home tomorrow. The kiddies, not kitties, the kiddies. We will share them tomorrow. Absolutely, Janice. It is time to wrap up. It is time for Twinkle Twinkle. It is time for all the things. We will share the four-legged friends tomorrow. If you're in the text crew, join it. If you don't follow me on social yet, do that if you want. I'll keep you up to date. And the other thing I forgot to say that I should have said way at the beginning. New merch is dropping on Monday. So Monday's the 15th. There will be new merch. I will tease it on social over the weekend. And that's it. That's all she wrote for this evening, friends. Go ahead and follow me on the socials. I've said that 7 times. I do repeat myself. I do wrap up too much. New merch, new family members of the four-legged variety, new, I don't know, maybe a new number on this thing. We might be hitting 91,000 here pretty soon. Emily's got to get her hair cut next week to start getting ready for all of this. Thank you guys so much for being here. Like, subscribe, give the mods a high five on the way out and thank them for being awesome. And I will see you guys soon. I appreciate the hell out of all of you. Thanks for being here. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.